50,000 rand. I want you to hold that number in your head. According to the National Prosecuting Authority, 50,000 rand was allegedly handed over in cash, in person, not transferred, not wired, handed over, face to face, allegedly to a police investigator. For one thing, the destruction of a case docket. That number, 50,000 rand, is just the deposit, the opening move. Because according to the NPA, the full price on the table was 1.5 million rand. That is what a senior officer in the intelligence division of the South African National Defence Force allegedly offered to make his legal problems disappear. And the man who came to deliver that cash? He was arrested the same day he handed it over. By members of the Madlanga Commission Task Team, a special investigations task team within SAPS formed at the President's direction to act on matters linked to the Madlanga Commission. This story does not end with the arrest. It gets stranger and darker. Stay with me.
May I understand the question again, Chair? It is only logical that for as long as dockets were in the repository, detectives could not access them as and when they wanted to. Is that correct?
It is correct, Chair.
Yes. That must mean during the period of storage, however short or long, investigations would be halted, correct?
It is correct, Chair.
Before we go deeper, if you are watching this and you care about what is happening inside South Africa's state institutions, hit like and subscribe right now. We are not going to stop digging. Let me introduce you to three people. The first is Brigadier General Johannes Prince Mkhabela, 53 years old, Director of Special Acquisitions for the Intelligence Division of the SANDF, a man at the top of South Africa's military procurement chain. To understand why that title matters, consider what the Intelligence Division actually does. It is responsible for gathering, analyzing, and protecting classified information that affects national security. And within that division, Special Acquisitions means Mkhabela oversaw the procurement of tools, technology, and capabilities that are not subject to ordinary public tender processes. This is not a desk job. This is one of the most sensitive positions in the country's defense architecture. His clearance, his access, and his institutional connections would have placed him in contact with information that very few South Africans are ever permitted to see. The second is Joshua Thembi Hlongwane, 41 years old, Mkhabela's personal secretary. In any institution, a senior official's secretary controls access to meetings, to communication, to the official's daily schedule. Hlongwane was the first person to allegedly make contact with the investigating officer, not the general, the secretary. That is the first layer of distance that was allegedly built into this scheme. The third is Athinandava Manik Mulaudzi, 39 years old, Mkhabela's legal representative, his own attorney. Now, before I tell you what allegedly happened, I need you to understand something about that third name. Mulaudzi was not just a lawyer in this story. He was Mkhabela's lawyer. He was supposed to be the man protecting him in court, advising him on his rights, ensuring the law worked in his favor. That is the role he was paid to fill. That detail matters enormously. Keep it in mind. According to the NPA, here is the timeline of what allegedly unfolded over 6 days. On February 7, 2026, a police investigator was already actively probing a case of intimidation registered against Mkhabela at the Pretoria Central Police Station. This was not a new case. It had been opened in January 2026, meaning the investigation had already been running for weeks before what allegedly happened next. That same day, February 7th, according to the NPA, Hlongwane contacted that investigating officer. The message, according to NPA spokesperson Lumka Mahanjana, was direct. Mkhabela was allegedly offering to pay 1.5 million rand to ensure the case did not proceed to court. Think about what that means. Not a hint, not a suggestion, a named figure, a price. 1.5 million rand. And it was the secretary who made the call, not the general himself. The secretary. That is deliberate. It is a pattern that investigators and prosecutors recognize. When a senior figure wants to corrupt a process, they rarely make the first approach personally. They use a layer, someone expendable, someone who can claim they misunderstood, acted alone, or exceeded their authority. The secretary is the probe. The general watches to see what happens next.
Inspecting dockets per provinces.
But the crucial thing, though, is your admission that during the time of storage, investigations would be disrupted. You've accepted that.
I do.
Thank you. That's all that I wanted to establish. I'm going to move to a second point, which I also think would have disrupted investigations.
The February 9th, 2 days later. Now it was the attorney who made contact. Mulaudzi, Mkhabela's own legal representative, allegedly reached out to the same investigating officer. His question, according to reports, was how much money would be required to have the case withdrawn entirely. Let that land. The lawyer asked how much. By this point, the investigating officer had been approached twice in 48 hours, once by the secretary, once by the attorney, both times allegedly on Mkhabela's behalf. The scheme was escalating. What started as a probe was now a negotiation. And then February 13th arrived. The brigadier general himself walked into the room. According to the NPA, Mkhabela met with the investigating officer in person. During that meeting, he allegedly handed over 50,000 rand in cash as a deposit. He then allegedly made a promise. The remaining balance, bringing the total to 1.5 million rand, would be paid by September 2026. In return, according to Mahanjana, the officer was asked to destroy the case docket against him, not shelve it, not lose it, destroy it. That word is important. Destroying a docket is not a bureaucratic act. It is the elimination of evidence, of statements, of records, of the investigative trail. It is the kind of act that does not just end one case. It poisons the integrity of every investigation that ever touched that docket. What Mkhabela allegedly did not know was that this meeting was not going the way he planned. After the alleged payment, members of the Madlanga Commission Task Team moved in and arrested him. The same day, on the spot, and there is more. In court, State Prosecutor Advocate Tholoana Sekonyana said there are audio recordings from those encounters, and she needed time for them to be downloaded and processed. The State Prosecutor, Advocate Tholoana Sekonyana, told the court she needed time to have those recordings downloaded and processed. Those recordings, she indicated, would prove the bribery allegations. This is significant. Audio evidence does not depend on the credibility of a single witness. It does not require cross-examination of memory. It either says what it says, or it does not.
Yes, General.
May I raise a concern?
Yes, General.
You know, Chair, there's no wrongdoing whatsoever that happened in the process. But the way I am being pushed into a certain corner that says, is there an instruction that says the docket must go to head office or not? I've never given such an instruction. It never happened that I said take the docket from head office to now. General, it was planned maybe. They decided to take the docket themselves to head office. Now it is on my shoulder, and I'm the one who must now bear responsibility why they left KZN to head office, when in fact I did not give such instruction. That's the only concern I wanted to raise.
Thank you, General.
On February 19th, Hlungwani and Mulaudzi surrendered themselves to police. On February 20th, all three appeared before the Pretoria Magistrates Court together. The general, his secretary, and his attorney. Now here is the detail that almost breaks the story open. Mulaudzi, the lawyer who allegedly approached the investigating officer asking how much it would take to withdraw the case, was now standing in that same courtroom as a co-accused, a defendant. And yet, during that same hearing, it was Mulaudzi who argued on Mkhabela's behalf, challenging the R1.5 million figure cited by the state. His argument: the state had evidence of 50,000 rand actually changing hands. They did not, at that stage, have direct evidence of the full 1.5 million. That is a precise legal maneuver from a man who is simultaneously defending himself and his client in the same case. Think about the professional, ethical, and legal complexity of that position for a moment. Let us slow down and look at these numbers carefully. 1.5 million rand. That is the total alleged offer, the price Mkhabela allegedly placed on making a criminal case against himself disappear entirely. 50,000 rand. That is the alleged cash deposit, what was physically handed to the investigating officer on February 13th. This is what the state can directly account for: physical cash, a meeting, an arrest immediately after. The alleged repayment deadline, September 2026, 7 months away at the time of the alleged deal. Why 7 months? That is a question the court will eventually have to consider. Was that a meaningful deadline or a delaying tactic? The co-accused received bail of 5,000 rand each. That is the price at which Mkhabela's secretary and lawyer were released, with conditions that included surrendering their passports and making no contact with state witnesses. 5,000 rand bail against a 1.5 million rand alleged bribe. The court clearly did not view those two individuals as the primary risk. The Brigadier General himself? Bail has not been granted yet. The state opposed his release, and the court postponed the bail judgment to 23 February 2026. The state argued he poses a risk of reoffending, and specifically, a risk of intimidating state witnesses. He already has a separate pending intimidation case registered at Pretoria Central, the same case that allegedly triggered the entire bribery scheme in the first place. In other words, the case that triggered the bribe attempt is the same intimidation case that the prosecution cited when opposing his bail. The net tightened from both ends. February 23rd is the scheduled bail judgment date for Mkhabela. That ruling will tell us whether the magistrate believes he poses a flight risk, a witness tampering risk, or a danger serious enough to keep him in custody while the prosecution builds its case.
General Sentumule has given evidence to this commission and testified that she was placed under pressure to collect the dockets, placed under pressure from you to take possession of the dockets. What's your response to that?
I would agree.
Johannes Prince Mkhabela was not a mid-level official who could be quietly reassigned. He was the director of special acquisitions inside the intelligence division of the SANDF. Special acquisitions. In an intelligence context, that phrase covers procurement of tools, equipment, and capabilities that are not publicly disclosed through normal channels. Think surveillance technology. Think specialized equipment. Think contracts that carry classification levels. This is a position of classified authority, of institutional trust, and of significant operational access. South Africa's defense intelligence structure sits at the intersection of military operations and national security. The people in it are not merely administrators. They work with information, relationships, and resources that ordinary law enforcement does not easily access, audit, or challenge. When someone at that level allegedly walks into a room and hands over cash to a police officer, the implications extend well beyond the 50,000 rand in the envelope. The idea that someone in that role would allegedly attempt to bribe a police investigator, destroy a case docket, and use his own secretary and attorney as intermediaries, that is not a small story. That lands differently when the title attached to the name is Director of Special Acquisitions, Military Intelligence. And there is a critical detail about how this arrest happened. It was the Madlanga Commission Task Team that moved in. This task team was formed to focus on matters linked to the Madlanga Commission, especially allegations involving senior figures and institutional cover.
You wait for the final report. Those dockets now have been there since the 28th of March. in all of that time, until it was returned, ultimately, in August, I believe, 2025, you would agree that no investigation was done on those dockets, correct?
I agree, no investigation was done.
The Commission is investigating corruption inside the highest ranks of South Africa's law enforcement and military structures. This arrest did not happen in spite of that context. It happened because of it. According to reports, Mkhabela's alleged intimidation case, the one he allegedly wanted buried, was opened at Pretoria Central in January 2026. Within weeks, according to the NPA, the alleged bribery scheme was already in motion. 3 people, 6 days, 50,000 rand in cash, and a request to burn the paperwork. Instead, the paperwork grew. What happens next? On February 23, 2026, the magistrate will deliver a bail judgment for Brigadier General Johannes Prince Mkhabela. That ruling will tell us whether the court believes he poses enough of a risk to remain behind bars while the state assembles its full case. But 3 questions are already sitting in the open, and none of them will be answered by a bail decision. First, if audio recordings of the alleged meetings exist, what exactly is on them? The prosecutor indicated those recordings would prove the bribery case, but the public has not heard them. The recordings were being downloaded at the time of the hearing. When do they surface? And what do they capture beyond the cash handover? Second, a man's own legal representative allegedly approached the investigating officer asking how much it would take to drop the case. That attorney is now a co-accused, was released on 5,000 rand bail, and argued in court on behalf of the Brigadier General at the same hearing. At what point does a co-accused lose the right to represent his fellow accused? Is that an ethical violation, a legal one, or both? South Africa's law societies will have a view on this. The court may too. And third, what is the intimidation case actually about? The case Mkhabela allegedly paid 1.5 million rand to suppress has not yet been ventilated in public. The person or people who opened it have not been named in the reports. What did a director of special acquisitions in military intelligence allegedly do that was serious enough to justify that level of criminal exposure? That question sits at the center of everything. Tell me what you think is happening here. Drop it in the comments below. If this story matters to you, share it. We are not going to stop digging.
Dockets sitting in head office for that length of time, not being investigated, is an interference with the administration of justice. And you said you would not agree with that.
From the neutral perspective, I agree with it. From a person who is neutral watching, not apportioning any blame to whoever, I will say it is true. It is correct.
It was very serious interference with the administration of justice.
I do accept that one.